The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to the Kansas Supreme Court and both counsel and to those who are watching on our Supreme Court live channel. I would ask Mr. Doug Shima to please call the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Wednesday, May 26, 2021 consists of one case. Appeal number 119834, Richard L. Hanson, Circle H Farms LLC, Rome Farms LLC, and Stegeman Farms Partnership versus the Kansas Corporation Commission and Texas, Kansas, Oklahoma Gas LLC. Cases out of Stevens County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Jeremy Graber, Folston Siefkin for the appellant, Texas, Kansas, Oklahoma Gas, present and ready for argument.
May it please the court, Lee Thompson of Wichita, representing the appellee, Richard L. Hanson, and others who are irrigators, and we are present and ready for argument.
Thank you, counsel. Mr. Graber, you may begin.
Thank you, Your Honor. This is an appeal of a decision by the Kansas Corporation Commission under the Kansas Judicial Review Act. It was initiated by the irrigators' complaint against my client, Texas, Kansas, Oklahoma Gas, concerning billing practices. The KCC's decision was in favor of my client, Texas, Kansas, Oklahoma Gas, TKO. And even though TKO is now the appellant, and I'm up here going first, Mr. Thompson and his clients, the irrigators, have the burden of showing the commission erred, and the commission's decision is presumed valid. That's the starting point here. It is not my burden, it's not TKO's burden to show that the Court of Appeals was in error. This case is not about fraud or misrepresentation. TKO never admitted there was any billing error, and the KCC expressly found no misrepresentation. These claimants are paying low prices for all the gas they needed in accordance with their contracts, in accordance with the certificate issued by the commission. Again, this court is reviewing the KCC's decision. The district court and the Court of Appeals decisions are essentially disregarded. And pursuant to established precedent from this court, the KCC's order can only be set aside when it is so wide of the mark as to be outside the realm of fair debate. And failing to...
Counsel, let me stop you right there. I'm not sure this is a concern or not. Both sides can weigh in on this, but judicial review under the statute is limited. And Mr. Thompson, when he filed his appeal for judicial review at the district court, raised 4 different subsections of the Judicial Review Act. When the Court of Appeals affirmed, it did so only looking at 2 of those 4, and it was silent as to the other 2. Does that cause us a problem at this level in how we can look at, for example, the C7 or C8 allegations, which were not discussed by the Court of Appeals, whether there were facts that were not supported by the evidence or unreasonable and arbitrary action? You see what I'm getting at?
Yes.
The Court of Appeals decision is limited. It still went against you, but it was limited. But if we decided the Court of Appeals was wrong for those 2 reasons, can we move over to C7 and C8?
Under the Supreme Court rules, Your Honor, I think Mr. Thompson was obligated to file a cross petition for review or conditional cross petition. And so his failure to do so for whatever reason, I think limits the review of only the C3 and C4 that were decided by the Court of Appeals, and the substantial competent evidence and arbitrary and capricious is not before this court and has not been briefed.
The reason I'm not sure I agree with you on that, is that when I looked at your petition for review, you didn't specify C3 and C4, you just went to C. So it's almost as if you threw a net over all four of them, even though you only lost on two, if you will. So I wasn't particularly comforted in holding Mr. Thompson to that standard when you seem to put it all into play.
I see your point, Your Honor. I think we're a little bit procedurally here in an awkward position. Even though I'm the appellant, he has the burden of showing the error. And I don't disagree. He filed his petition in district court showing 4 points of error. And frankly, getting out in the weeds, I think the KCC's decision is right for all four of the subsections. Mr. Thompson spends a significant number of pages in his briefing arguing the facts. I feel like our briefing responded to that as well. But I still think as a practical matter, under the strict reading of the rules of this court, the only issues that have been appealed from are C3 and C4.
Does that mean then if we remand to the Court of Appeals to consider whether any error was made under 7 or 8, if they didn't reach that issue?
Again, I don't think if they didn't reach the issue and Mr. Thompson failed to cross appeal and this court does not want to take that up, I don't think it's remand back to the Court of Appeals. I think that the decision is whether all the issues are before the court or not. To be honest, I haven't thought too much about that, but it doesn't seem like it's proper to go back to the Court of Appeals if Mr. Thompson didn't at least seek review of those issues before this court. And I think really getting down in the weeds, I thought about getting up here during my time and reading the KCC order and where it addresses the issues raised by the Court of Appeals. I didn't think that'd be a good use of my time, but their fundamental holding is that the commission finds and concludes, this is paragraph 23, that the non-residential complainants, the irrigators, have not met the burden of proving that TKO's rates or practices with regard to them are unreasonable. This goes to the very heart of the case on the failure to decide an issue, failure to apply the correct law, and the substantial competent evidence. The KCC's core holding right there is that they failed to carry their burden on the facts. This was an evidentiary hearing on the merits, and they failed to carry their burden. That's a negative finding. And the negative finding can't be reversed unless it was arbitrary disregard of undisputed evidence.
Mr. Graber, the Corporation Commission did hold that your client failed to disclose the two different pressure base numbers that it was using to calculate the bill. And why can't that failure to disclose that the commission found be sufficient under the statute to be either, unreasonable, unfair billing practices, unlawful billing practices?
I don't think the commission held that we failed to disclose it. I think it held it was not included in our contracts along with the entirety of the billing practice. And I don't think that failure to not include every provision of a billing practice in a contract is inherently unreasonable on the facts, as the KCC decided. There's no mandate to include or not include a provision in the contractual agreements with the customers. And I think that goes back to the certification proceeding. These contracts, as they were written, were approved by the commission. So the commission approved the contracts as to form when TKO received its certificate provisionally in 2010 and then in the final order in 2012. So I don't think the omission of all of the billing practices is unreasonable. And the other piece of that is, let's not forget, this billing practice is more than just the pressure base that Mr. Thompson and the irrigators have focused on. There's also the atmospheric pressure, which is never addressed anywhere by the Court of Appeals, District Court, or really Mr. Thompson. where TKO's practice is actually to the benefit of the customers. And if we did the exact match, it increases their bills by 2.5% or thereabouts. In our position is all these facts and all these issues, these complicated billing practices were before the commission, where it held an evidentiary hearing, 2-day hearing, 8 witnesses, cross-examination, all that. And the commission that's been vested with the broad discretion by the legislature decided that this billing practice was not unreasonable on the facts.
Council, quick question about our standard of review. You're obviously pushing hard for deference to the commission, and you're framing this all as an evidentiary matter. Would you agree with me that the Court of Appeals clearly stated and viewed it through that this was an error of law?
I agree that Court of Appeals clearly decided this was an error of law.
And our review of that decision is de novo, correct?
That's correct, Your Honor.
So I guess I would just ask you to address that, the rationale that was actually in the Court of Appeals holding. Why are they wrong that when they held that the KCC misapplied the law or made an error of law?
I think the Court of Appeals main issue here is that they assumed there was a billing error. They assumed that the irrigators were receiving less gas than they paid for. And based on that assumption, they said even if the end price is in the ballpark, that's still an unreasonable billing practice. And that was the fundamental error. It's built on this acceptance of Mr. Thompson's arguments that there was a billing error, and they weighed the credibility. I mean, from their opinion, it discusses that the company consistently provided 10% fewer MMBTU than the irrigators believed they were paying for. Well, that's a credibility determination of what the irrigators thought they were getting or what they thought they agreed to. And on page 95, TKO misrepresented the amount of gas that irrigators were receiving and consistently overcharged them by 10%. That's a factual determination that is specifically contrary to the commission's holding. Paragraph 12 of their order on reconsideration. The commission simply could not find the complainants proved manipulation, misrepresentation, or unreasonableness. So, Your Honor, what they've done is they've taken assumed facts and said, well, if you assume these facts are true, then we have a legal error by looking at the end price. And that is how the court, in my opinion, the Court of Appeals erred in this case. And I agree, issues of law are de novo, but the issues of law here is what is unreasonable, unfair, or unjust under 66-1, 205. Boiled down, they filed a complaint based on the single theory of exact matching and of all the billing components. And based on the evidence, the commission did not find the rates or practices unreasonable. They failed to carry their burden at the KCC, and they have not shown reversible error under the KJRA, particularly given the broad discretion granted by this legislature. And accordingly, we ask this court to affirm the commission's decision and reverse the Court of Appeals.
Counsel, can I just ask then, as a matter of law, how is reasonableness defined per the relevant statute? Is it broad enough to include billing procedures or non-disclosures of the type at issue here? What is your definition, or what is the accepted legal definition under the statute?
Of reasonableness?
Yes. Reasonable, fair, just.
Well, I think it's hard to define. The cases, the utility cases, they look at what's the zone of reasonableness. You look at almost the totality of the circumstances. You look at everything that goes into the sausage making process. Does the sausage come out? Is that reasonable? As it applies to this billing practice, I think you look at every billing practice component. You can look at whether it's disclosed in the contracts, whether it was required to be disclosed in the contracts. And I think all of those things are appropriate for the commission to consider when they're evaluating the reasonableness of the practice. And the quote in the Court of Appeals decision where they're citing, I think it was Blacks, I don't remember if that's correct, on unfair, I don't think that's an unreasonable definition. But when you come at it the angle that the Court of Appeals did, where you assumed there was a billing error and receipt of less MMBTU, then of course that's unfair and unreasonable. But they jumped the gun. They didn't evaluate the billing practice itself that the commission evaluated at the underlying evidentiary hearing. Your Honor, if you're no more questions, I'm finished with this part of my presentation.
Okay, thank you, Mr. Graber. Mr. Thompson?
Thank you. May it please the court, Lee Thompson of Wichita. I represent the Appalese who are irrigators in Western Kansas. They purchase gas from TKO to run their pumps to water their crops. I think that the issue of the governing statute is pretty important, and just going to the last question from the court, I would refer to KSA 66-1205, which gives the commission authority to investigate complaints as to any unreasonable, unfair, unjust, unreasonably insufficient or insufficient, unjustly discriminatory, or unduly preferential of any service performed, etc. It is a very, very broad authority. And under that authority, my clients filed a very specific complaint. And knowing that I'm going to impinge my own credibility, I'm going to suggest that it is a very simple complaint. It focuses on a discrete practice, and that was that they had been consistently overbilled due to a mismeasurement of MMBTUs in the gas contracts. That was the issue presented to the Court of Appeals, and that was the issue that the Court of Appeals ruled was not addressed properly, was not addressed at all by the Corporation Commission in its final order. So let's
Counsel?
consider. Yes, sir.
On that note, the scope of their investigatory powers, what it is broad, but what guides their ultimate decision making? Is it under the same standard of unfair, unjust, unjustly discriminatory, unduly preferential? What is the bottom line standard that the KCC is bound by in reaching the conclusion of their investigation?
I think that's tied into how you frame the issue, Justice Wall. I think that if you say the issue is an overall question of rates, for example, there is a standard as to reasonableness of rates under various decisions. But if you focus the issue on this precise mismeasurement issue, I think that they are empowered and clearly authorized to look at mismeasurements that simply don't accurately measure the quantity of the fungible commodity.
So if that's the case, and just assuming that there's a situation where there is an inaccuracy in that sort of process, but at the end of the day, the ultimate rate that is generated from that process is still reasonable, is that sufficient grounds to conclude the investigation without an adverse finding to the utility?
No, it is not. The reasonableness of rates in this case is in my humble opinion, a red herring or a straw man argument advanced by TKO to take the focus off the specific misconduct which we allege. Rate cases are highly complex, and the authorities they cite, for example, Kansas City Power and Light, which gives deference to the court to the commission on rate cases is the granddaddy of all rate cases, the Wolf Creek Power Plant case. And as the court noted, those kinds of cases involve predictive analysis of cost and rate of return and all of those sorts of things. So that is an entirely different issue and one that is not presented. The rate here is clearly, I will agree, it's in the contract. My clients don't complain about the contract. They simply want some accurate measurement of MMBTUs. And so I hope that answers your question.
Counsel, the Court of Appeals ruled that the commission's order was invalid under subsection C3, which is the failure to address an issue that needs to be addressed. And it said that that missing issue was the billing practice of TKO. And that was an argument you made. But as I look at the order and particularly the order on reconsideration, it seems to me it's pretty obvious that the commission ruled on the fairness of the billing practices as well as the rate question. I know you disagree with that, but I want you to explain why.
I think the answer to that comes to perhaps the standard of review issue, which you raised ab initio in this argument, and that is whether or not the courts are empowered to review the evidence of the record as a whole. And as it relates to this, the question is, what evidence does the commission cite for its finding that it was reasonable or not manipulated? The interesting thing in this case is we implicated and asked for the review by the commission of technical expertise on mismeasurement. And the technical expertise of the commission was that it was mismeasured because what TKO did was take one measurement of the heating quantity and then measure its own billing of that quantity at a different level. And it's not some esoteric exact measurement, it's a principle of science, as all three experts testified. So I think in that sense, one needs to look at the evidence cited by the commission to support its finding. They say it was not manipulated, for example, and that evidence was, and you look at the explanation, the evidence was it was not manipulated because TKO always did it the same way. Our position is that consistency of misrepresentation is not exculpatory. In fact, we argued they'd done it that way all along, and that was improper. There is also an argument, certainly as it relates to the overall concept of mismeasurement, which I've already gone into. So I think that this court or the Court of Appeals can, and if they haven't, they should properly look at the evidence as a whole and look at the explanation of the evidence. And certainly the fact that it was always done the same way leaves one wanting for some substantive analysis.
And I appreciate that. But my problem is that everything you described is a C7 analysis. That's looking at the evidence based on the record as a whole. And the Court of Appeals didn't do that. It hung its hat on C3. It said that the commission was only looking at the reasonableness of the rate at the end of the day and didn't look at the billing practices. And I think that's wrong. And if I'm right, I mean, if the rest of the court agrees with me, then we get to Justice Lukert's question of, do we have to remand this back to the Court of Appeals to actually look at the C7 aspects of this case, or can we move on to do that ourselves?
I think that's perhaps beyond my competence level, but I turned to the most recent examination of the Judicial Review Act, which I could find, which was the Red versus Kansas Truck case, which indicates that subsection D of 77-621 alters an appellate court's analysis in 3 ways. Requires a review of the evidence, both supporting and contradicting, requires an examination of the presiding officer's credibility, and it requires review of the agency's explanation as to why the evidence support its findings. That's subsection D, and I think that would seem to apply across the board. If it would require a remand to the Court of Appeals, I could live with that, but I don't think it's necessary.
And counsel, I'll drill into that same question a little bit further. My understanding of your position is that the commission held as a matter of law that for you to prevail, you had to demonstrate the rates were unreasonable. And your position is, as a matter of law, we don't have to demonstrate the rates are unreasonable.
No,
We can prevail in other ways.
I'm sorry, I interrupted. I think that the reasonableness of rates falls into the explanation of their analysis. Their analysis for upholding TKO's action was based in very large measure upon some theory that we were trying to implicate or revoke the private contracts.
Well, let me just sorry to interrupt. Let me just draw your attention directly to the commission's ruling, paragraph 48. And the commission stated that the burden rests with the complainants to prove the rates are unreasonable and against the public welfare. Do you think that's a correct statement of the law or an incorrect statement of the law? Because I read the Court of Appeals as saying that's where the commission erred as a matter of law.
Well, I guess I think that we did prove that they were unreasonable, and because the rate is the contract, the rate is the contract price. I'm sorry.
Well, I guess I'm just trying to ask something slightly different. I understand you believe you proved they were unreasonable. I'm just trying to understand the Court of Appeals opinion, which I read as saying to the KCC, look, that's an error of law. The complainants, the irrigators, don't actually have to prove the rates are unreasonable in order to prevail. So the Court of Appeals is saying to the KCC, you constrained your own scope of review contrary to Kansas statute.
I agree, because they defined the issue as a reasonableness of rates, and the issue was not reasonableness of rates. That's the best way I can answer that. I'm not sure how my time is at this point.
You have about 3 minutes left.
All right. I would like.
That paragraph seems to make a switch in terminology that I wanted you to address, and that is in paragraph 48 of the commission's order. One sentence says that the plaintiffs contend that TKO's billing practices are based on an invalid calculation methodology that results in unjust or unreasonable rates. The next sentence says the complainants rely on this argument alone as evidence that the practice results in unjust or unreasonable rates. Is that a fair summary of your argument, or have they conflated two issues or by restating it the way they do in the second state sentence?
I think they clearly conflated two issues, because the whole question of rates in this case is interesting. The certificate issued to TKO was on the basis of contracts. They were certified to serve pre-existing contracts. The contracts were all negotiated with the predecessor, not TKO, and they contained common terms, MMBTU, a common unit of measurement, dictated by the NGPA in 1978. So I think in our brief, we tried to argue and did argue that the conflation of the issue of reasonableness of rates to superimpose that over the real issue presented here is erroneous. Might talk just very briefly about the MMBTU standard. The interesting thing is that, of course, gas is sold based upon the BTU content, and that has to be measured. And then there's a volume. It used to be MCFs, which is a physical evaluation. When you convert the MMBTU to a volume, you're simply doing a mathematical conversion. And I would urge the court, and we did urge the Court of Appeals, to look at the specific expertise of the KCC on that, their own utilities division. We looked at our own expert, Mr. Hanson. We looked at outside experts saying that in that conversion, it is critical. And in this case, it's particularly critical because TKO gets its gas from Anadarko. And then by the sheer fact of altering the number by which it compares pressure bases, it inflates the revenue. And that is the reason they did it. They admitted that. So we think that's improper, unfair, and unjust. I think that probably pretty well concludes my time.
Are there questions? Thank you, Mr. Thompson. Mr. Graber, you reserve 3 minutes.
Thank you, Your Honor. I think where I'd like to start in my remaining time here is the focus of the Commission's decision of the complaint filed by the irrigators, and all the way back to paragraph 6 of the complaint. Complainants allege and state, based on available information and belief, that the rates charged by TKO to complainants are unreasonable, unfair, and unjust. So the Commission is faced with a complaint that is alleging unreasonable practices and rates. The only way we get to figure out a refund is the end price paid by these customers. So somehow we have to come up with a value. That's where this 9.5% comes from. You can't necessarily divorce the practice from the end price. I'll call it the end price so we don't get confused on what rate means. But somehow the end price has to come into play with the practice. And I'll refer to paragraph 41 of the final order in the middle. The crux of the complaint is that TKO employed an invalid methodology for calculating the BTU of the natural gas it sold to complainants and therefore overcharged them by 9.5%. I don't think that can be a more clear statement of their argument. The Commission went on and had to decide, were they able to carry their burden?
Can I jump in there and ask the same question that I asked your opposing counsel, which is draw your attention to paragraph 48, and then it's also repeated at least in paragraph 50, where the Commission said the burden rests on the complainants to prove the rates are unreasonable. And I guess my question is just very simply, is that a correct statement of the law? In other words, the Court of Appeals seemed to say, look, petitioners or the irrigators could prevail simply by demonstrating the practices are unreasonable, even if the rate isn't. That seems to me to be the legal controversy here. So I would like you to address whether or not you think, what is the law? What do the statutes require the irrigators to show? Do they have to show that the rates are unreasonable?
I think the irrigators have to show either rate or practice is unreasonable. I think, Your Honor, that can be an either provision. So if you want to put the rate.
So then it would seem to me that the Commission ignored the practice side of things and just said, look, we are focused exclusively on whether the rate is reasonable. And if the rate is reasonable, it's good.
I disagree with that, Your Honor. first of all, from the quote I had of paragraph 41, they understood what the complaint was about, was the practice. Paragraph 46, there was no evidence the billing parameters were manipulated in any way. Paragraph 51, although they take issue with the calculation methodology, the commission does not believe the methodology employed makes TKO's rates unreasonable per se. And I understand it says rates right there, Your Honor. But somehow we have to turn this practice into a dollar amount. And again, this laser focused attention on practice ignores what's happening here. We have the gas coming through the pipe, and here's your displacement meter, which measures volume. And that's the MCF that Mr. Thompson was talking about. Then we have to make assumptions to convert that to MMBTU. And in this calculation here, that's the problem. But in this calculation, it's complicated. You have the pressure factor. You have the atmospheric pressure. Mr. Thompson acts like the BTU is easy to calculate, but the uncontroverted evidence was you can't calculate that on a day-by-day basis. It varies considerably based on the constituents in the gas. Some are heavy, some are light. This is wellhead gas, refined gas. Mr. Hanos, the technical expert at the KCC, said there's no easy way to do this, and up or down, the BTU varies, and someone's losing money. So in this practice, you have to evaluate the totality of what TKO is doing and has always done and say, is that reasonable? And we assume these contracts from Anadarko. We asked the irrigators, did your bills go up 9.5% when TKO took over? No, not one testified that the bills went up. You look at the facts of what happened, which was all before the commission, the bills didn't go up. TKO, if they wanted a certain billing practice and they wanted it spelled out in the contract, we could have simply said, we'll adjust our rates and the end price to the customer would be reasonable.
So just to sort of cut to the chase, it sounds like your argument is the KCC actually did evaluate the practices and find them to be reasonable. It just perhaps didn't articulate that in its order as clearly as it might have.
I agree with that, Your Honor. They evaluated the practice. We have one laser focused attention on one narrow billing practice. Is that unreasonable per se? They said, no, it's not. And they had the burden of proof in this case to show unreasonableness. TKO didn't have to show it was reasonable. They had to show it was unreasonable. In paragraph 23, the commission finds and concludes that the irrigators or the non-residential complainants have not met the burden of proving the rates or practices are unreasonable. And if they didn't support their decision enough, the only proper remedy is to remand to the commission to decide the issue in the first instance. We don't think you need to go there. We think the standard is clear under the KJRA. The commission did enough. The irrigators have not shown error to reverse the commission's decision. So again, we are asking this court to affirm the commission and reverse the Court of Appeals.
Mr. Graber, paragraph 38 of the commission's first order has this statement in here that says the actual violation here is that it was not disclosed. That's using the two different pressure bases. Now, it's pretty obvious to me that there's substantial competent evidence to support a conclusion that there wasn't disclosure. And so then it's a legal question as to, I guess, as to whether that's a violation of anything. But let's assume there wasn't disclosure, as the commission says here. Why isn't that a violation of the statute about an unreasonable billing practice that you're not disclosing? You know, here's something that's a problem, having two different values in the stream when you're calculating the bill. Why doesn't that fall under the statute?
I think having two different numbers in the stream is not wrong. I know that's Mr. Thompson's argument, but that is not inherently wrong.
The commission says it wasn't disclosed.
Mr. Hanos said it wasn't disclosed. And I would agree the commission found that it's not included in the contracts. Now, I'm not certain whether it was ever disclosed or not disclosed, I don't think there was any testimony from the irrigators that it was hidden or that there was any misrepresentation. And that's the basis of their argument, is that there was misrepresentation of what they thought they were receiving. And that's what the Court of Appeals stated, which we argue is incorrect. And this, when Mr. Hano says the actual violation here, well, I don't agree with Mr. Hanos. I don't think the commission did either, that there was an actual violation. We have a contract that doesn't have all the billing practices set forth in it. What the irrigators want to do is add a contract amendment going all the way back to 2007 and strip 9.5% of revenues, not profits, back to 2007 for only one billing practice component. If we want to do exact matching, we got to do the whole ball of wax, and we have to evaluate the effects of that on the utility. Again, the KCC is weighing the interest of the utility, ratepayers, and the public interest. You strip 9.5% of the revenue all the way back to 2007. They set their rates based on this billing practice to come up with an end price that's reasonable and fair. If we want a different billing practice, we should be able to adjust our rates to come up with the same fair number.
But that's I take that argument really to fit in support of the Court of Appeals order, which reversed the district court. The district court ordered a refund. The Court of Appeals said, no, we're not going to do that. We're going to send it back to the Corporation Commission to balance all those interests and figure out what the right result is. So I still get back to, how is a failure to disclose this billing practice not a violation of the statute?
Is failure to disclose an unreasonable practice? I think that's the question that the commission, I don't think that was ever argued before, Your Honor. Is failure to disclose a billing practice that no one has alleged other than the irrigators. No industry person was called. They said this is not based on industry practice. So on the facts, is there a requirement to disclose every aspect of a complex billing practice? And I think a fair reading of the Court of Appeals decision is, if you don't match the pressure base, it is unreasonable. So if that is unreasonable, what can the commission do on remand except do exactly what the Court of Appeals said must do as being reasonable? And this is where I think the issue turns into, do we have a judicially mandated regulation that all pressure bases must match, or else it's unreasonable? And I think the issue was before the commission, who decided on the facts. This billing practice itself is not unreasonable, and failure to disclose is, what's the harm here? They don't allege they paid too much for the gas. They don't allege, they would agree they would have paid more. So again, I think you have to look at the end price if you're going to look at what's reasonable and just under the totality of the circumstances.
There are other questions? Thank you to both counsel. The court will take this appeal under advisement. Court is now in recess until 1:30 this afternoon.